Thank you. I appreciate the introduction, and sorry for playing it safe, so to speak, and rather not engaging the video in fear of being cut off again. Yeah, I think there's not much to add to what Byron has said about me, and we've dealt with many projects together. I come from a family of entrepreneurs, so being focused on serving their legal needs, I think, was to a large degree a natural progression for in life for me. Schoeman Law deals with all legal matters, actually, except criminal law. We do outsource that, but in-house we deal with every matter except for the criminal side, as I said, and also some IP we also outsource. Then, other than that, we also run an online contract builder tool. The brand for that is linked to Schoeman Law is Contracts for Biz, and I'll tell you a little bit about that later. Pocket Advisor actually launched now in COVID. Wasn't planned that way, or we were working on it and planning to launch sometime towards the middle of this year. So it just happened to be in the same time. And it's essentially a teaching tool that has been combined with a legal compliance tool. But again, we can deal with more about that in a later slide. So I prepared a little bit of a slideshow. I'm not sure if I'm able to use the sharing. Seems that someone else is sharing their screen.
Let me just stop that for you, and then you can share your screen.
Great. So if you want the slides, I can pass them on via Byron, not an issue. So I would like us to have a bit of an interactive session. We can deal with question and answer at the end, not a problem. Or you can, if something is really pressing, we can maybe use the chat box and have it interactive. It's not really my intention to have expose you to a boring legal lecture. Can everyone see my screen?
Yeah, thank you.
Okay, sorry, let me there we go. All right, so COVID-19, definitely a lot of risk from a legal perspective, lots of uncharted territory, but I don't want to bore you with the bad news. We have enough of that, and I think we are suffering from a clear overload with reliable and unreliable sources. So let's maybe look at, yes, some of the complexities, but also how you navigate your way through this to react, of course, and be proactive, and obviously also to lead you into a space of thinking where you can recognize some of the opportunities it presents. So firstly, I need to add a disclaimer, as any good lawyer will tell you. This is not legal advice. I'm sharing this with you for educational purposes, hoping that you can use some of these building blocks towards building some of your own solutions, or at least having a clear idea of what you could do when and if you would need to take legal advice. So I believe legal advice is done in a very tailored way, one-on-one. So please, I'm sharing with you in good faith, and all I can do is ask you to respect that. So this is me. I'm Nicolene Schoeman Low. I have an LLB, LLM, and a postgrad in financial planning. I'm an attorney, a legal project practitioner. I'm a conveyancer, notary public, and I'm a mediator. So many, many hats. But I feel I've got a lot of tools in my proverbial toolbox, which help me to, in essence, solve legal problems creatively and effectively. So what I wanted to share with you is, firstly, some aspects of insurance, what to look out for. I'm sure you've heard of business interruption insurance. Maybe some of your businesses are affected by this, maybe they're not. Then, of course, landlord and tenant is becoming very topical. Everyone's talking about it. Many people are having problems surrounding it. And then supply chain, and the legal Latin term that everyone seems to know what it means now, the force majeure. and how that actually works, or how one should apply it in these circumstances. So, okay, let's just go. So business insurance, it seems that my connection is giving me some trouble again. Hello?
Yeah, we hear you.
There we go.
Yeah, we hear you.
Okay, so my screen share is stuck, but let's go on and I'll share the slides afterwards. So on the business insurance front, broadly speaking, we have two types of policies that are linked to what we commonly refer to as business interruption insurance. So business interruption could be a component to your existing short-term policy, or it could be a standalone policy. In certain sectors, it's usually standalone, and it's quite expensive actually. So first step would be for you to ensure that you know what type of policy you have. Do you have a loose standing business interruption policy, or do you have a policy that is incorporated into your normal short-term business insurance? Once you've established that, I know this is quite tedious, but for you to actually read the policy document would be quite critical, and to see what the procedure or the claim triggers, so to speak, would be. So in terms of the policy that is built into your short-term policy, usually, and again, this depends on the policy document itself, would entail that there needs to be a damage event. Now, in this instance, a damage event would mean that the building is burnt down, or the building has been destroyed by some event, or something that would normally be claimable under your short-term policy has now happened, and that in itself is ensuring or resulting in a business interruption situation. So that's the first type of policy. I'm just going to see if I stop sharing my screen and I redo it, if we can get the slideshow working, but in the meantime, I'm going to go on. The other option, or the other type of policy, is the standalone business insurance or business interruption insurance, which doesn't need to be coupled by a damage event. And usually these types of policies have pandemics or epidemics and diseases as the trigger events, which ensure that you are able to claim under the policy. So if there's any uncertainty as to the type of policy you have, now's the time to find out, to read the policy document, or have your broker advise you how that policy document works, or how that policy is structured. And then, of course, knowing what you are insured for, and then, of course, acting accordingly. So that's quite an important first step for you to see what portion of the revenue loss that you may be suffering as a result of not being able to trade during this lockdown, but also as a result of COVID-19. So importantly, many insurance houses are taking a step forward and saying that from their perspective, they feel that business interruption in terms of the event that triggers interruption, a national lockdown or a similar situation, cannot be a trigger event. So just watch the media whether your insurance house has maybe made such a statement, and whether or not they are of the view that they are not seeing the lockdown as a damage event. So it's important to actually go back to all the mountains of paperwork and to ensure that you know what the situation is. Then if we move on, I don't know. I'm unfortunately not able to stop the share. I think I've got a screen freeze. So apologies for that, but I'll ensure that you get the slides. From a landlord and tenant perspective, let's move on. The landlord and tenant, we've seen, was actually one of the first sets of regulations that the DTI actually issued under the state of disaster proclamation. So that was the first set of regulations that we saw coming out before all the other regulations on essential goods and services followed, and the amendments on top of the amendments. We anticipate that tonight we'll see more amendments on top of amendments, but be that as it may, we will have to watch this space quite closely. So from a retail landlord-tenant perspective, some of the first regulations that came out were to deal with that. And obviously from the restriction of movement of people and movement of certain goods, inevitably retail would probably be along tourism, and similar sectors would be the hardest hit immediately. So that's, in my view, the reasoning behind why we saw those regulations as the first ones. So these regulations came out, and we saw that it dealt with the retail sector, and effectively what it means from a technical perspective is that they've relaxed portions of the Competition Act. The Competition Act deals with healthy competitive practices in a marketplace, and essentially it allowed landlords the space to enter into more lenient agreements with their tenants without being accused of disturbing the natural balance of competitive operations or business dealings. So that was quite important, and it definitely sets the stage for that to happen. A few weeks later, on the 7th of April, we saw that the big retail landlords, all the JSE listed companies, came together and they released what they call the tenant relief package. And the tenant relief package essentially has incorporated some deferments, some payment holidays, and all sorts of things. But of course, not all retail landlords belong to this newly established industry body. So although the stage is set for negotiations to happen and for reductions or deferments or payment holidays to happen, there's no aspect that can actually force that to happen. And that's quite important. So it means that any person that has an agreement with a landlord, or any landlord themselves, would need to think critically in this time and consider their options, look at their contracts, look at whether it deals with the force majeure. As I said, one of those Latin, actually French phrases in this case, that everyone seems to be debating and knowing the meaning of. So quite important for us to look at that and to really go to the negotiation table, not just with the view of renegotiating the immediate effect of not being able to trade immediately prior to lockdown, in lockdown, and whatever would come after. So ideally, with all the renegotiations we are doing, and we're doing a lot of them, literally on a daily basis, between 4 and 6. And most of them need to consider perhaps pre-existing issues between the parties. Maybe some of the issues were unresolved or in the process of being resolved. Now you've added this to the already existing mix of issues. So it's really critical for, I think, tenants also to think in 2 minds. Firstly, to remember that as much as they are under pressure, the landlords are also under pressure. If all the tenants are not paying rent or not communicating, it will have exactly the same knock-on effect that it would have on on an entrepreneur who's strained by all these obligations, but there's no income or there's no revenue. So we need to consider the perspective of the other party. That's the first important point that I want to leave the landlord-tenant discussion with. And secondly, also to look at this from a broader perspective, that we need to negotiate around a longer-term strategy, not less of a knee-jerk reaction based in or founded in fear. So people are very quick to say we need to cost cut now, and I'm not saying that isn't true. We need to be smart about how we are spending our resources. I completely agree with that. But similarly, I also think it's important for us to go through the internal processes needed and to SWOT everything that is going on in our business in the current context and to make smarter, better decisions. So essentially, it's important that you do not just start paying your rent on own accord. Have that conversation, prepare yourself for what you are going to negotiate around, what it could look like post-lockdown, or at least build a caveat into that saying, this is our immediate solution to alleviate the pressure. We'll reassess it in this way or at this point. So that is, it's important to remember that none of these issues have recipes or steps that can be taken in all instances sequentially. It's important to know that you need to consider the circumstances of every situation, every relationship, and to really critically think about what you are hoping to achieve when the renegotiation is done. It's not just a financial aspect, there's a clear relationship component to it as well, which I'll get to in a minute when we deal with some negotiation skills. I hope I'm not going too fast. Please stop me if I am.
No, I think you're going fine, Nicolene.
No, all good.
Right.
All good. Sorry, I just struggled to get. But if you want to, you can cancel I did try and stop your screen share from this side. And then instead of making it a presentation slideshow, you can just open PowerPoint. That should show correctly then.
I think my problem is that my machine is frozen.
Okay.
And I don't want to inconvenience you with a
No,
fourth
let's keep
replay.
it.
So don't worry. I may leave out some references to case law, the citations and that sort of academic thing. But I'll make sure that I get the slides to you and you can pick it up from there. As entrepreneurs and as South Africans, we are creative and resilient, and I'm hoping to illustrate that. So let's go to the supply chain side of things quickly. So supply chain and the force majeure. So supply chain has inevitably been interrupted for many industries. We have seen that we have delays on performance, delays on delivery, that we have orders that are being cancelled. All of these contractual aspects are now being discussed, and everyone is asking, but at what point or where does my responsibility end in regards to such an agreement that hasn't quite gone as anticipated because of COVID and because of all these strange things that are happening around us. So firstly, one needs to look at the building blocks of contracts as a whole. So contracts, obviously, by definition, is the structural component, the written component of a agreement verbally reached between people. So you talk about a deal, you discuss it with someone using whichever media, and you reach a point of consensus where both parties accept where you are, and then I urge you to please record that in writing. Makes a lot of things much easier. You'll sign a contract and there you go. So now that we've gone back to the basic building blocks, when something goes wrong in a normal circumstance, then you often have certain remedies that would flow from it. So no COVID is happening, no lockdown is happening, someone doesn't do what or perform as they were supposed to, then you can either claim for damages, you can cancel the contract and claim for damages, or you can force them to do what they had undertaken to do. And that's essentially the specific performance. So these remedies still exist. And the force majeure is basically a component that is either added into a contract, or there's a common law equivalent of it called vis majeure, which is basically, it boils down to the same thing. It's the so-called act of God, and it means that something uncontrollable for no fault of either party to the contract has made the contract impossible to follow through on in the normal way. So I think one thing is for sure in this unique situation that we are all finding ourselves in is that the courts have all said we haven't had any cases coming out of court, no debates happening in the legal fraternity to the degree that COVID-19 and lockdown isn't viewed as a force majeure. So we agree that it's something that is no one's fault and it's preventing the follow through on contracts in the normal way. For it to be a force majeure, there are three things that the event must comply with. It must be unforeseeable, unavoidable, and impossible to overcome. Those are the three components. So it's important also to know what it is not and how the courts actually think about it. And this is what will lead me to telling you that although there seems to be consensus that COVID-19 as well as the lockdown is a force majeure, there's also an argument to be made in particular circumstances that it is not. So it would depend on when the contract was entered into and whether the force majeure existed at that point. It also would depend on the monetary obligations or the non-performance of it, the extent, what is at stake in essence. And then if there has been any delays on the performance or the performance of the contract in the normal course by either party. So essentially, if we look at landlord and tenant, because a lot of the case law that we have to work with actually date back as far as the late 1800s, early 1900s. And it's quite important to see the context in time of that component in order to explain this principle. Essentially, back then we were in a war situation, the Anglo-Boer War, and similarly the transportation or the movement of alcohol was also prohibited as it is now. And many of those cases that came out and went through the entire system up to the then highest court in the land involved liquor stores and disputes between landlords and tenants because the tenants were unable to sell their alcohol, their liquor, and they were unable to make money in order to pay rent. And the courts had to deal with this situation, much like we anticipate they'll have to deal with it now if people don't start talking to each other. And in essence, we saw that the court said that if there's a possibility to perform a contract when you enter into the contract and subsequently something unforeseen, no one saw it coming, happens, in other words, the force majeure occurs, it's the same legal effect as if the force majeure existed in the first place. So essentially, if that component is present, it means that you have a stand down. No one can do anything. The obligations to a large degree are frozen in time. So landlords will, for many reasons, including this principle, not be able to enforce their agreements right now. But that doesn't mean they can't try and do that after lockdown is lifted. And similarly, tenants will not be able to have other recourse against landlords, by example, right now. And the same will go for suppliers and consumers. So importantly, to know that these clauses are often built into contracts. So you'll see these clauses. Maybe it's a good thing for you to go through any of the contracts you're involved in and see if you have any of these clauses built in. If you do, all of those that I've seen to date, and I've reviewed 2 or 3 dozen of them in the last 2-3 weeks, haven't dealt with a pandemic or a mass situation of lockdown in this context. So there could be a clause, but in all likelihood, it probably won't address this particular situation, which means you'll fall back on the common law position, which is basically the 3 components that you'll have to prove. And then you'll have to make a decision on whether or not you want to honor the agreement, perhaps negotiate postponement of performance, potentially a different pricing. It obviously depends on which side of the table you find yourself on. And in regards to that, it's important for us then to look at some negotiation skills. Negotiation is one of those skills, I think, that are presented in to attorneys to learn, especially if you're a mediator. As I said when we started, it's one of the things that I'm quite passionate about is mediation and how powerful it is in regards to resolving disputes. So mediation, firmly founded in solid negotiating skills. And I'm sure if you've been in the entrepreneurial space, most of you would have had to test your own negotiation skills in your business life cycle more than once. But there are some key components to consider when you do look at these types of agreements. And one of them is definitely to consider the relationship impact that it would have. So firstly, you'll need to sit down and make a list of your objectives. What are your goals, your priorities, and your possible trade-offs that you can make, whether it be in the landlord-tenant context or whether it be in a buying and selling context. So map out what is your absolute lowest offer that you are willing or able to sustain. Then, of course, is this a win-win or win-lose situation? In other words, will both of us have to compromise and we'll walk out winners in the bigger scheme of things? Or is one going to compromise and possibly feel that they've compromised, but the other hasn't, and they're the loser and you're the winner? And that is an important relationship dynamic to remember, because that will help you address some of the inherent fears that could flow from that situation and some of the reactions that could flow from that situation. Is this a relationship that would need to continue, or is it a relationship that you are quite okay with ending? In a landlord-tenant scenario, or even with a supplier or a customer, you would need to know whether you can afford to burn this bridge, especially if this is linked to your ability to earn a revenue, to earn income. Then it's important for you to know where this relationship fits in and to what degree you are able to risk damaging it or not. Then, of course, what do you do, or what's the outcome if negotiation fails? If you fail to renegotiate terms or extend or discount, what is the alternative? Now, of course, any lawyer will tell you the alternative is it's unresolved and we need to fight about this. I challenge you to consider all options, not just to litigate, to go to court, to consider the option of a roundtable discussion, but a roundtable discussion with an agenda. Don't go into a roundtable chit-chat and a tea party that leaves emotions running high with frustrations and fear, and inevitably feels like a massive waste. So that is quite important for you to look at what the outcomes could be if the talking at this level fails. Then, of course, the strategy that you have. Are you going to go into the negotiation with a proposed alternate agreement that you have had drafted, or an addendum, that you prepared? Or will that be perceived as being arrogant or presumptuous? And if that is perceived that way, it could hamper your ability to renegotiate. Or are you simply going to go in with an agenda and a structure? Then, of course, identify the key issues. And that goes back to the agenda and back to your strategy, to go in prepared and to know what the positions are. And I found it very useful in this time to pull out the old SWOT analysis and to apply that to every facet of your business, not just, I almost want to say on a high level, but that you apply it to every facet of what you feel is potentially impacted. So if you want to SWOT your clients, your current and new business opportunities, then do that and go through the relevant process to identify what you think needs improvement or is a risk or a weakness, etc. Do that then repeatedly with your stakeholders, with your creditors or expenses, however you wish to phrase it. But look at your business from various different angles as you do it. So for some people, it works well to umbrella the SWOT and to go through all facets of business and to record it sufficiently detailed so you really don't miss a thing. For others, it helps segmenting the business operations into 3 or 4 key components and to SWOT each component in isolation. And that really helps you to leverage new ideas, to identify which of your agreements would be impacted if you want to end the relationship, if you want to amend it to fit into a new reality, or if you need to renegotiate it in some other way. And that goes back to the landlord and tenant as well. And then, of course, through this exercise, it could be very useful to identify any new opportunities that you may not have thought about before. Many of our clients have actually, through this process, indicated that although it started with such doom and gloom, having to look at how they could potentially pull the belt in, so to speak, what other avenues of new business could be opened through that. And we shouldn't underestimate the creativity that can take place in this scenario. So I want to conclude and leave you with one of the key aspects, I think, for us to look at in this COVID situation. So many of us are accustomed to remote working. Many of us have had to become accustomed to remote working. I myself have been remote working on and off for a very long time. All our systems at the firm have been set up in order to allow flexibility. So remote working was fairly easy for us to transition into completely with 3 days notice. 1 or 2 people had never done it before and were new to our team. So I think it's been an adjustment for the minority in our group. But many people have had to learn to do this or have realized that their businesses are not enabled to withstand something like this if it were to happen again in future. So I think if we look at that, there's a useful testing opportunity here, and that's the tech side of me speaking. Useful to test, useful to ask these deep questions, and of course for you to identify what may or may not quite be working as well as it could. So with that, then I want to leave you with our Contracts for Biz platform. Essentially, it's document automation. It's the engine driving it is a document automation software, and it's a web-based tool. We haven't developed it to something further than that, but it's evolving all the time. And essentially, we thought of using it in two ways. Firstly, to make reliable contracts that we know people are downloading from unreliable sources, or copying and trying to edit themselves and creating litigious situations. In other words, dispute situations that make lawyers very rich, but entrepreneurs very poor. So we knew that this was happening, and we wanted to give an opportunity to download something that you can trust and something that is workable and compliant, and it doesn't break the bank. So we were able to cut out the human in assembling the document, and by doing that, we've brought the pricing down by 90% of the usual rate. So tangibly, 1,500 rands contract now costs 150 rand. We did that for the small business and startup sector, but similarly, this has evolved, and it's helped us quite successfully for clients to have negotiation documents at their disposal when they go into their own negotiation. So they have a document which is a starting point, and we know the document, so we can be contacted and we can build onto it, whether it be an addendum or an extra couple of clauses or whatever the case may be. And that means you only pay for that update, not for someone to read a document, not for someone to interpret it, and thereby we are also able to reduce the cost quite significantly. So I challenge you to have a look at the platform. Registration is free. There are a couple of free documents also on there that showcases what the tech can do. It's still very robust. We are working on an AI-driven component, which will launch when the data pool that we are working from in South Africa is a little more stable and a little more, a little stronger than it is at the moment, and better sourced. But that's the future of what we envision with this. And then also to look at other technologies, including blockchain, to see how it could integrate with different versions of smart contracts. So it's evolving all the time. We're adding more documents. We're adding supportive measures that are all free of charge that you can use and play around with. And hopefully it helps you navigate what has become a very, very challenging environment, but definitely not impossible to overcome. So despite all the technical issues, I hope that I've given you some things to think about, and let's take some questions.
Well, thank you very much, Nicolene. That was a back full and a lot of good insight. So yeah, if anybody's got questions for Nicolene, please raise your hand. You can do it like Wendy did yesterday by literally raising a hand, or you can just raise your hand via Zoom, and then we will try and answer it. Any questions? All right, Jennifer. Jennifer, yeah, you can go.
I just going back to the landlord issue.
Yeah.
I would like your comment on a residential tenancy arrangement.
Sure. So yeah, regrettably, the regulations that we saw that I referred to earlier, and as I said, I'll give you the, I'll send the slideshow to Byron and you can pick up the references from there. The exemptions that they published all relate to commercial environments, particularly retail. So to date, nothing other than when the regulations were amended last week, Friday, the 17th of April, where you are unable to evict anyone from a residential property for not paying rent. Other than that regulation, we haven't seen any guidelines we are hopeful that maybe tonight will include that. But I would recommend, I'm not sure if we're talking from perspective of landlord or tenant. I'm going to assume that you are the landlord.
Correct.
You would I would recommend that you actually have a conversation. Some landlords in the residential space have gone the route of not evicting, but also not giving rental holidays to people that are working remotely. So if they're working remotely and they are still, life is going on as per usual, except for movement, then there should be no reason for rent reductions or for non-payments to happen in the first place. So have that conversation and do a bit of a due diligence. If they're saying, listen, we're going through some financial trouble, you need to ask the tough questions and say, okay, provide me proof or a letter from your employer stating that they haven't paid you, or you're on short time, or you're being retrenched, or whatever. And then, of course, to make an alternate payment arrangement with them, or deferring the rental payment, and signing an acknowledgement of debt for the deferral. So whatever you do record it in writing, so that if default happens, that you are able to deal with it and to decide what your options are at that point.
Yeah, I'm not keen to evict or anything like that. However, the agent presented some documents that are highly suspect, and asked me to make a decision. And I just threw it back to them and said, can you see the omissions? So I was just wondering, like what I can really expect from the agent in this case, as they are supposed to be representing my interest.
Yes, they are, absolutely, yeah.
And also because the tenant has provided these sus documents, I'm not interested in evicting her, but I'm annoyed that this would be presented.
Okay, so your agent first and foremost needs to represent the interests of the landlord. It's the landlord's agent. They get paid to represent your interests. So first and foremost, that's where their loyalty should lie. Secondly, if there's any renegotiation that is happening in regards to the lockdown period, you need to ask why the tenant wants an alternative arrangement. And if their position is that they are not being paid because they're on short time or they are being retrenched, then you need to see proof of that. And you need to expect, you need to make arrangements as to what would come next. So if they've been retrenched, you would be careful. It would be my advice to you, because they inevitably, most people are not going to be hiring new staff right now. So if they are retrenched, the reality is that they could be jobless for a very long time. So then it's probably better to negotiate a notice, if that is so, and say, okay, 3 months or 4 months for you to find alternative accommodation, and to sign a cancellation agreement to that effect. And then hope that the tenant does the right thing and that they honor the agreement. Otherwise, you could have to evict them at that stage. Does that make sense and answer your question?
Yes, it does. The documents that are provided are what you're talking about, but as proof of income about seeking the government benefit, it was that they've had a successful application. Anybody can do that. Yes. And the proof of retrenchment was on a letterhead without an ABN, without an address, without a phone number. And when I looked up the name, when I looked up LinkedIn, the person who represented themselves as the managing director was not the same person on LinkedIn. And
Ooh.
there was a spelling error in the document as well. So that's what I mean. I'm quite annoyed for both the tenant tabling these documents and the agent for not doing their due diligence.
No, that's definitely that definitely sounds fishy, and I feel that the agent should do the due diligence, and you should keep them accountable. That's why they're getting commission.
Great,
Yeah,
thank you. Thank you for
I just
that,
needed
Jennifer.
confirmation that what I was feeling wasn't over the top.
Yeah, okay. Fair enough. You need to look at your mandate that you signed with the agent. But usually those types of mandates entail that they manage the relationship. Not just a case of getting the tenant and placing the tenant. It's also a case of managing the relationship. And if that is so, then my advice stands.
Yeah.
Brilliant.
Thank you very much.
Thanks for that. Yeah, we've got Karen. You can go for your question.
Yeah, just to provide some context, Nicolene, Jennifer is in Australia, but I would presume that the advice you gave has some universal avenues that she can take.
Yes.
So it's just the essence of what Nicolene is talking about is all I needed confirmation of.
So the jurisdiction-specific provisions are basically how to terminate the arrangement or the relationship, and that is we've got law in South Africa regarding that, and that deals with residential evictions. But it will all falls back on the contract with the agent, the mandate with the agent, and what you've actually hired them to do. What role are they to play?
Thank you very much.
Only a pleasure.
Was that your question or your statement, Karen?
No, it's just a statement. I just wanted to clarify that.
Thanks, Karen. Then Malcolm, you up.
Hi, Nicolene.
Hi.
Nicolene. In terms of your pocket advice or pocket diary program that you've got, is it directly linked to the advice that you give to clients, or is it a separate service?
Okay, so it's not okay. So firstly, to answer your question from a technical perspective, Pocket Advisor is not related to Schoeman Law. So Schoeman Law is an incorporated company, limited liability, Inc. In other words, as most doctors and lawyers and so on. And Pocket Advisor is a private company, PTY Limited. So it's two distinct entities. Firstly. I've got other partners in Pocket Advisor that I don't have in Schoeman Law, secondly. And Pocket Advisor is a platform that is essentially a combination coaching, teaching tool. In other words, you can do online courses there. And as you go through the courses, it actually allows you to assemble certain legal documents as part of the course outcomes. So when you graduate, you've learned a couple of skills as an entrepreneur, and we've got 4 programs, a leadership program, early stage right through to mature entrepreneurship programs, and each of them is coupled with different documents that you need to have in place in your business. So the engine that runs the documents is the Contracts for Biz engine, to be transparent, and that is owned by Schoeman Law, and we maintain it, we make sure it's legal. We make sure that if someone's unhappy, that you have somewhere to go, that there's a warm body that can deal with the complaints.
Brilliant. Thanks for that comprehensive answer. I assume that a client of Schoeman Law would benefit by using the Pocket Advisor.
We hope so. We've done a lot of research in our journey in launching our Contracts for Biz platform, which was done in 2018 already. Actually, it's going into its 3rd year of existence, and we hope that through all the data we've collected as to why businesses fail, that we can address more of it than just the legal aspects, that we can address the leadership component that seems to be missing, the strategic problem-solving skills, the skills level as a whole that seems to also often lead to failure. and later on that we can build that into tax and financial compliance.
Yes.
We need
Yes.
to recruit the right people to help us build the content.
Yeah, that makes sense. Thanks very much, Nicolene. I am in Cape Town, so I'll be in touch with you. The other questions, I don't want to take up too much space here. So I will be in touch with you. But thank you very much, and thank you for Byron for arranging this. This is very, very useful contact to have. Thanks very much.
Yes, on that note, Nicolene, I just want to say again what Malcolm just said. He stole the words out of my mouth. I will definitely also be in touch with you shortly. There's a couple of people on this call that needs to be brought under wraps. I won't mention name, but one starts with a T. But in any case, yeah, no, that was extremely unfortunately we run out of time for questions. But your contact details has been placed and Byron has got it. Anybody who wants to get in touch, please do. It's difficult to find a decent procureur. Sorry, I didn't say that. I meant lawyer. So really what you've dealt with us today is phenomenal advice and information. And I am sure a few people are going to be in touch with you, especially from the crypto side. So yeah, really, really appreciate it. Thank you.
Only a pleasure, and feel free to pop any questions over. I know sometimes these open forums may feel a little intimidating, so I don't mind answering any questions. I'll share the slides with Byron, and if you have any questions, anyone, then you can pop it through to me. Not an issue. And then